Bronson versus Michigan Assigned Claims Facility. It's okay. I don't care. I
Rest of the stuff.
oh, okay.
You don't know.
It's fine.
Thank you. What?
Okay. I thought that was for their benefit.
I was going to this.
That's why we have the sign.
How do we know that?
Okay, now you do.
I thought that was it. Why don't we buy two?
Got one.
Of course.
May it please the Court, my name is Lori McAllister, appearing on behalf of the Michigan Assigned Claims Plan. With me are my colleagues Courtney Kissel and Mike Phillips. This case is undoubtedly not the case on your docket that presents the highest amount of dollars at issue. However, it is a case in which there is a desperate need for direction to be provided to the lower courts of the state of Michigan as to whether or not the Michigan Assigned Claims Plan has the ability to review a claim and determine in the first instance whether it thinks the claim is obviously ineligible. And secondly, if the claim is moved along the line to a servicing carrier, what does it mean? The dichotomy that exists is clearly evidenced by this decision as compared to the Bronson versus Titan decision, which we filed as supplemental authority. In Bronson versus Titan, the court says this was assigned to the servicing carrier, and there's therefore a presumption that any investigation that needed to be done to determine eligibility was already done, or they wouldn't have sent it on. In this case, where we, in fact, looked at the non-evidence that was submitted by the claimant, indicating that there was no basis on which to determine that we had an eligible claimant, the court says, well, you're not allowed to do that. You should be passing this along as long as there's a material question of fact which exists. And then you have what Mr. Gavin advocates for, which is there's only a ministerial role that should be played by the Michigan Assigned Claims Plan, and there should be a presumption that they apply that says that the claims are eligible. You see lower court decisions that find all of those things exist. There is not a dispositive opinion from this court that would indicate to the lower courts whether the assigned claims plan can in fact make a substantive evaluation when a claim is presented and make the determination that the claim is not eligible without passing it along, and do so at more than a ministerial level. If we look at the decision of the Court of Appeals in this case, they basically criticize the assigned claims plan.
Why was the claim obviously ineligible?
Because there were only two factual situations presented, neither of which in this particular case would result in eligibility to get benefits from the plan. First, you could have had what we think occurred here, which is an uninsured driver, and that's clearly barred by statute. The other option is that there was insurance, and they just haven't gone out and found it at this point.
So let me can I stop you right there. If it's that simple, that does seem easy. But help me, because I just don't understand how this works. And I think that's one of my problems. If he was insured, but the insurer couldn't pay, it went under. He bought from Richard Bernstein's storefront insurance, and they went under.
Totally expected.
Well,
you tell me, but I think he would still be eligible, right?
No, he wouldn't be, Your Honor, because the Michigan Property and Casualty Guarantee Association picks up all insolvent carrier claims.
Okay.
So even though there's an exception there for the statute list, that is one potential basis that an eligible claimant can pursue.
Right.
It's solved for by a different statute and a different scheme.
So if that were to happen, if that, obviously this is like a unusual fact scenario, but I'm just trying to understand if you're right about there are only two possibilities.
Right.
So it's not exactly two possibilities. There's sort of one and then two, but 2A would still not get assigned. 'Cause
That's correct.
What if Cody shows up with amnesia?
Well, that situation, Your Honor, if it had been presented to the claims plan, I think that in that situation, they could evaluate it and determine whether they were going to deny it based on the fact that there were no affirmative proofs, which I think they would be entitled to do, or they could say these are extenuating circumstances and we're going to do additional due diligence. The fact is that they have the choice under the statute whether to deny a claim or not.
The standard, though, is obviously ineligible.
Correct.
Okay. And is Cody with amnesia? He's clearly the owner of the car, but he has no idea whether he was insured or not. Is his claim, therefore, obviously ineligible under those circumstances?
Yes, Your Honor, I think it would be, and this is the reason. All you would need to do is run a report, which Bronson eventually did here, that would show whether or not the vehicle that he was in at the time of the accident, if he was the registered owner,
He's a registered owner,
and whether or not there was insurance on the vehicle.
Well, how do you find the insurance, whether the insurance is on the vehicle?
Through the reports from the Secretary of State. So he
okay,
could have.
I don't understand. Now there's a fact in the record that I didn't understand. Bronson releases Cody, who vanishes into the ether, except on Facebook, and apparently lives in Port Huron. but Bronson couldn't figure that out.
Apparently not, and they should have.
But they did figure out, somebody figured out, that he was the owner of this, the registered owner of the vehicle.
Correct.
Why couldn't they figure out if it was an insured vehicle or not?
I don't think that they made an effort to do that, Your Honor. But the assigned claims plan could have done that. They didn't do it because there was no evidence presented. It's a question of whose burden is it, Your Honor. And in the no-fault world, we always say, whose burden is it? I think it is the claimant's burden to come forward to show that they are going to fit under one of the applicable eligibility requirements. And the registered driver owner is in the rather impossible situation of being able to make a claim because they are uniquely situated. There's a statutory exclusion if they're not insured, and if they are insured, then that gets priority under Section 3114.
Let me sort of try and march down. If Cody shows up at the facility and says, I want insurance from the facility,
yes,
they say, you're the registered owner of the car. Are you insured? He says either, yes, I am, and if he's yes, then they look to that insurer. He says, no, I'm not, he's disqualified because he should have had the mandatory insurance.
correct.
Now we have Bronson, who has apparently no computer system, stepping into Cody's shoes. Is that legally correct? That the provider has no greater or lesser standing for facility coverage than the owner of the vehicle?
Yes, Your Honor, we believe that they must stand in the shoes because they only have recoverable costs for payment of medical benefits to the assigned claims plan if
they may have some other source.
Correct.
But they have no right to no fault coverage if the person they treated has no entitlement. Right.
And in fact, they concede, hey, if this person was uninsured, we agree that we wouldn't have a claim. But yet...
You know, there are things that always stun me. This is, the missing fact here is susceptible of discovery, just like Cody was. I don't know how I could find him, but Bronson couldn't. But the fact, you know, he had a registered vehicle, and you therefore apparently have the access to whether that vehicle at the time of the accident was insured. Well, why did nobody bother to get that piece of information? Wouldn't that be dispositive?
Your Honor, I don't think you need that piece of evidence to conclude that he's obviously ineligible. But I understand your point The decision was made at the beginning of this claim, as I understand it,
You wanted
to
to
deny
come
it on the
here.
basis.
Because you need
Well,
a ruling
Your
from this
Honor-
court making it their affirmative duty to do that. Is that the idea?
That's right, Your Honor.
Okay.
I mean, this firm, Miller Johnson alone, has filed over 200 cases this year alone with this kind of proof or worse. We need direction from the court that says whether or not we can, in fact, investigate, whether we can, in fact, deny something as obviously ineligible. I think the statute on that is clear, that we have that right, but the lower courts don't. We get decisions every day saying, well, you have to assign it to a servicing carrier. You can't do that investigation that you and I are talking about.
I'm sorry. I want to make sure I understand how it works. So this computer system that you could have run through to find out if it was insured, does Bronson have access to that?
I honestly don't know, Justice McCormick.
Okay, I can ask that later.
I apologize.
So they come to you with not very much information. Either he had insurance or you didn't. We don't know.
Right.
You, instead of running his name through the computer system, come to court because you need some guidance from us. Totally understand that. Makes sense. If you had assigned it, I just want to understand what happens at the next. If you had just assigned it because you didn't care about the guidance from us, who has what burden at the next phase? I just want to understand how it works.
See, that really is the problem with this issue, because Bronson has the burden in the next phase. I mean, there's no question, I think, that under the No Fault Act, you're not entitled to be paid benefits unless you present a prima facie case to be paid for benefits. And in fact,
they have the bill.
They have the bill, Your Honor, but they don't have evidence that they are eligible under the statute to qualify. This is not a usual situation where we know there's an auto accident, they go to their insurer and tender it. I mean, we have a situation where we have a police report that doesn't list any insurance, even though there's a place for it.
So what usually happens in these cases? They get to the next phase and then Bronson loses? What's in it for them then?
What usually happens, honestly, Your Honor, is they get settled because they're too expensive to litigate.
So that's what I wanted to know.
So we don't end up getting a case that's tied up in the neat bow that we would all like and probably prefer to argue the merits of this position on. Because the reality is, if we're going to have to litigate out every case.
So you assign it to
State
Farm, and State Farm says, okay, Bronson, bring me your proofs. And Bronson files motions of discovery, and then State Farm's like, oh, God, here's $15,000, will you go away? Is that what happens?
I wish it were quite that easy, but no. Usually what would happen is that there would then, somebody would hire somebody, a private investigator, to try and go find Cody where he is. They would subpoena the records of the state to find out for sure what the state records say in terms of ownership as well as insurance. And there would be a discovery process, regular motions like you go to court. But at the end of the day, they are hung up on the fact that they want the assigned claims servicer to do all of this, and their position is that the claims plan cannot. And that is the fundamental principle of law that we think was not properly decided by the Court of Appeals in this case. While there is an open issue, an open fact as to whether he was insured or not insured, it's our position that that open fact is not material to the determination of eligibility. If they want to come back with something that we would say exists only in theory, such as, well, Cody had two different insurance policies and nobody knows which is primary.
Right.
If they want to come back with that, then they start the process and they can go forward with their claim.
Okay.
But they didn't do that here. They want to be able to make a claim, say, well, we don't know, you figure it out. And that's fundamentally why we say we are entitled under 3173A to be able to get in there and make that decision.
In the future, don't hire the investigator, just get the Chief Justice. He finds people on Facebook.
Well, I am rather impressed with his skills.
A Luddite troglodyte.
Thank you.
Good afternoon, Your Honors. Joe Gavin on behalf of Bronson Methodist Hospital. I'm going to start by talking about what I believe is the false dichotomy that's being created by the assigned claims plan here. Their view of the law is such that it's either or. It's either Mr. Escobar's insurer who would pay this claim or no one. We agree that if Mr. Escobar were uninsured, that this claim would be barred from benefits. We disagree, however, that it would be only submittable to Mr. Escobar's insured. That's the false dichotomy that is being created here by the assigned claims plan, or they're attempting to create. In our view, it's unsupported by the plain text of the statute. The MACP wants to argue that Bronson stands completely in the shoes and does not have an independent claim to benefits in this case. But that's unsupported by the statute. The statute, the Act, routinely distinguishes between who the injured party is and who the claimant is. That language is replete throughout the Act in making that...
interrupt your fire-free zone, but isn't that the issue that we're going to be looking into in the Covenant case?
It absolutely is, Your Honor. And I think in that respect, this case dovetails well with that case. Fundamentally, if you look throughout the Act, you will find exactly that kind of distinction throughout the Act, whether or not the injured person is making the claim or there's an independent claimant.
Do we need to decide the Covenant case before we can sort out this case?
I think that the Covenant case is certainly going to be instructive in terms of this case. In my view, if this court...
Will it be an outcome determinative? If it, in fact, the healthcare provider gains no greater entitlement to benefits than the patient, wouldn't that be outcome determinative here?
It may or may not be, Your Honor, and here's the reason why. I can conceive of a situation in which Mr. Escobar, as you pointed out, may have amnesia. And in that situation, it wouldn't be outcome determinative. Because in effect, Bronson is not coming in and effectively bound by Escobar's amnesia. They're an independent claimant.
What I don't understand, though, perhaps you can help me understand, is I've just learned if you can figure out that he is the registered owner of the vehicle, you can then figure out whether he had insurance on that vehicle. Is that not true?
That is not accurate, Your Honor.
Okay.
Our client, we have access to certain information.
No, I don't mean you.
Me, yes.
I don't mean you or your client. Is it ascertainable, if you know the name of the owner, the registrant of the automobile, is it ascertainable whether that car was insured at the particular time?
It is not, Your Honor. That is a fundamental thing that we run up against routinely in these cases.
Separate from your ability to, and your clients, I'm just saying, is that ascertainable?
Oh, you mean in theory?
Not in theory, in reality. Can somebody, perhaps not insurance hospitals, but is there somebody who can access a database that associates insurance with a registered vehicle?
My understanding is that there are some people that have access to that kind of information, yes.
Obviously, the police do, right?
Well, the police have access to Secretary of State records, which shows registration information. The Secretary of State, to my understanding, does not actually maintain insurance information that the police can access. Certainly, my client doesn't have it. Certainly, I don't. My understanding is that there are many in the insurance industry that have that kind of access. We do not. My client does not, and is unable, in circumstances like this, to obtain that kind of information.
Does your client routinely ask those who are involved in an automobile accident whether they're insured?
Yes, my client does routinely do that, but you have to understand, Judge, as a practical matter, sometimes they're able to get that information, sometimes they're not. If someone is presenting for treatment from a motor vehicle accident, they're often not having the information, they don't have the information available. You may be unable to communicate with them. Bronson, like many other hospitals, has registration personnel trying to acquire this information when they can. Sometimes they can. Sometimes they can't. And in situations where they cannot, they will often conduct supplemental investigation post-discharge. I'm going to take exception.
But not use of computers and social media.
to the extent that may provide some information, absolutely. So for
the rules that we make create incentives. It strikes me, now I don't know why Bronson didn't get the information initially, but it doesn't strike me, if I can find out that he lives in Port Huron and apparently had some Jaeger bombs the night of the accident, whatever Jaeger bombs are. I think they're probably alcoholic.
Don't pretend like you don't know.
I've heard it. Never had one, but I've heard it.
No comment, Your Honor.
No, that's a millennial drink, I'm quite sure. if I can figure this out, what incentives would we create if we didn't place on the healthcare provider at least to utilize those resources to present as complete a package to the facility as you can?
Well, and let me back up. The statute already has incentives built into it to do that kind of diligence. Bronson routinely does, and in this case I would take exception to the idea that it wasn't done. Bronson routinely does, when the statute says can be identified, when 3172 says can be identified, there is, in my view, there is a reasonable diligence standard assumed by that language. And in that respect, Bronson does undertake reasonable diligence to try and find and locate insurance. Now, in a situation like this where someone doesn't want to be found, doesn't want to communicate with you, goes dark.
I agree, but this is not one of those cases, apparently.
This is one of those cases where there would have been the court's subpoena power, potentially, to force Mr. Esquivel to the table once litigation was filed. But that was never an option because the immediate reaction of the MACP was to file a motion for summary and have the claim dismissed. So we never got access to the court's subpoena power.
You didn't even know where he was to ask him. That's the point.
At the time of whether or not, when the suit was filed, if we knew where he was, honestly, Your Honor, I can't say whether or not we knew where he was at that time or not.
Anything preventing you from suing him directly?
In theory, that's correct. There's nothing that prevents us from suing him indirectly. But as an independent claimant of the Act, my client, we believe, has a statutory right to pursue a claim for no-fault benefits. And I would go back to the point that I started on here at this point, where I distinguish between Esquivel and Bronson.
Point being that if you needed to invoke the court's discovery process and subpoena power, you could do that by suing him directly, right?
We could, in theory, but we also run the risk at that point of running afoul of 3145. If we don't do so within the time requirements of the Act, we effectively waive the claim. So by suing Esquivel, potentially hailing him into court, trying to get that information, we're always running up against the one-year back rule and the time file requirements that are extant under the statute. Okay. Getting back to the question that I started with, in terms of what exactly the distinction is between Esquivel and Bronson and why I believe this is a false dichotomy, if you look under 3145, if you look under 3104 sub 5, the Act talks specifically about injured people versus claimants. If you look under the assigned claims provision of the statute, it actually refers specifically to claimants. 3173, the language that we're dealing with specifically in this case, requires the assigned claims, Michigan Assigned Claims Plan to evaluate, quote, the claimant's eligibility for benefits.
Aren't you just arguing covenant now?
Yeah, that's what I was.
And that's why I think it's an important, in that respect, I suppose it does dovetail well with the case. And maybe I'm previewing some of what our position will be in covenant.
It's a little appetizer for us.
Exactly. I'm hoping you enjoy it. But that's certainly, it does dovetail precisely here.
So we should hold off on deciding this case until we decide that one? Is that what you're saying?
I wouldn't presume to make that decision for you, Your Honor, but in my view, I think that it's clearly the case.
You can presume to say whether you think it's logical for us to try and decide this case before we decide covenant.
I think that is a very reasonable response to this application, Your Honor. That the covenant decision, whatever happens there, may have some direct bearing on this decision because of that language that you find replete throughout the Act. I'd note that 3172 also talks about a person claiming benefits, not an injured person. And because that language, you find it distinguished throughout the Act, our position is that Bronson is a claimant, is entitled to obtain benefits, no-fault benefits, under 3157 and 3107. So as a result, if that's the case, Bronson is the one that needs to be, its application is the one that needs to be considered, not Mr. Esquivel's alleged eligibility or ineligibility. Okay. I would also address the point that with respect to...
I just want to make sure I'm following this theory.
Yes.
So even if he's uninsured, it doesn't matter for your claim?
No, I disagree with that. We do concede that if he is ultimately determined to be uninsured, that our claim would be barred. But the key is here, and this is where the false dichotomy is that the Act contemplates that there are maybe some circumstances where a claim can be paid by a servicing insurer, by the MACP, and then that servicing insurer has the legal right and responsibility to go after priority coverage. And that would be under...
If he is insured.
If he is insured, exactly. So, for example, in this case, the claim gets submitted to the assigned claims plan. In our view, the proper procedure
is all about who has the burden. They're right. You're trying to foist it on them, and they're trying to foist it on you.
Our view is that the no-fault system itself is designed to capture these kinds of claims. It's exactly the kind of thing that former Chief Justice Taylor talked about in Kreiner. It was the great compromise. We are exchanging limited tort remedies, and in exchange, we get the right to submit these kinds of claims.
He never even heard of provider suits when he said that, did he?
Perhaps not.
And we hadn't even evolved to this point yet.
There's also
What's your
a
understanding of the practical answers to the questions I was asking? If it were to be assigned and say it gets assigned to State Farm,
Yes.
then what? Do you have a burden then, and what is your burden?
Yes, absolutely. Now the State Farm has an obligation to make prompt payment of loss in accordance with the Act. In our view, that means that State Farm has the same time requirements that any other insurer has under the Act. Once a provider presents reasonable proof of the fact and the amount of the loss, the carrier then has a decision to make. They have 30 days under the Act to decide, are we going to deny the claim, or are we going to pay the claim? In this case, assuming State Farm believed that Mr. Escobar was uninsured, they could deny the claim, and then we'd be right back in litigation, potentially, over whether or not that's a payable claim. We would have the court subpoena power to make Mr. Escobar come to the table, and we could depose him, find out if he is insured or, in fact, is not insured.
But it would be your burden to at that point.
It would be our burden to prove that actually Bronson incurred reasonably necessary medical charges for reasonably necessary care and treatment in Mr. Escobar's care and recovery. That's what our burden to show is. We wouldn't have the burden to show, in effect, that Mr. Escobar was uninsured at the time. That's an affirmative defense under 3113B that the carrier can raise or waive in its discretion if it chooses to do so.
Okay, so the advantage to you is then it's on them
If they in fact want to assert the affirmative defense of a constructive owner operating his own uninsured vehicle. That is a burden that they have if they want to assert that defense.
Well, right, but that is also presumes that they have the burden of figuring out whether they have that defense. So automatically, State Farm has to now figure out what's his name? And
I just call him Cody.
okay, where is Cody and
Cody
what is the
of,
status? They have to figure that out so they know whether they can plead the defense. So it pushes off that work, that cost of figuring that out onto them. Is that sort of fair to say?
I would say that it's fair to say that with respect to their burden on that exclusion, it's absolutely correct.
Okay.
So to the extent they conceive of that as a cost that is borne by them, I agree it is. Whether or not it is an unfair cost, I don't think is a question before the court.
No, I
the question
understand.
about a fairness of cost is, as the court has instructed us routinely.
You're suggesting the only burden of the providers to establish the bona fides of the bill. Whether it is in fact a no-fault claim or not is not the burden of the provider.
No, I am suggesting that the burden of the provider is to show that an individual has sustained accidental bodily injury arising out of the ownership, operation, use of a motor vehicle as a motor vehicle, and that as a result, there were reasonably necessary care and medical treatment provided and incurred reasonably necessary charges for that.
Basically, you're only saying, all I have to prove is there was an auto accident that caused the injuries. The fact is whether the injured party was required to carry insurance and didn't is not your concern.
Whether or not Mr. Escobar carried insurance ultimately is dispositive of the question. I agree with that.
But not your concern, as the provider.
Well, I would disagree with that slightly, Your Honor. In respect, it's always our impulse and desire to find the highest priority coverage available.
Yeah.
It is much easier than coming here arguing this case before you. It's better for my client to identify and bill appropriate priority no-fault coverage and not to chase claims that are, in fact, dead ends. If this ultimately turned out to be a dead end, that would not be a good investment for any one of my clients. The bottom line is we want to get to the truth as soon as possible, but because of the 1 year back, we often can't get to the truth as soon as possible. So we have to make a decision about whether or not we're going to pursue a claim through the assigned claims plan or not.
Okay.
The final point I'll make is with respect to this issue of cost, because I heard the MACP, Ms. McAllister, talking in terms of the number of applications that my firm submits. We submit a number of applications every year. It's certainly true. We represent another number of hospitals. In our view, then the bottom line is the assigned claims provisions, the No-Fault Act itself is designed to capture precisely these kinds of claims because of that trade-off that the legislature made. Individuals, all of us, none of us, have the right to sue under certain circumstances because of this trade.
How can that be when no one knew what a provider suit was when the No-Fault Act was created and when it was amended, and all the way up to about 4 years ago when I was a trial judge, and you all figured out that you could file some direct lawsuits and they would work their way through the system. So I'm just trying to figure out how it is that the legislature knew something that the lawyers didn't figure out for 30 or 40 years.
I'm going to save that for my colleague in Covenant, Your Honor, because I only have 5 seconds left. But my expectation is that's a question that will be squarely addressed in the Covenant decision, in particular if this court decides to hold this decision in abeyance pending that.
Well, I can't wait.
Thank you, Your Honor.
The first thing I have to say is I hope my partner Jill Wheaton is watching this stream, since she'll be here to argue covenant in front of the Honorable Court. Just a couple of quick points. First of all, he wants to treat this case as if it wasn't a litigation matter. I mean, we moved for summary disposition. If they wanted to try and create an issue of fact, if they wanted to try and go out, find Mr. Esquivel, they had the legal ability to do that and argue, come then to the court and say there are disputed facts. They did not do that. That was their burden. And the reason that they didn't do that was explained by Mr. Hillary, Mr. Gavin's partner, when at page 17, when he was arguing his motion to the lower court, he said, we agree that this case should be decided now. There's really no need for Bronson and the Michigan Assigned Claims Plan to engage in discovery here. The reason they are here is because they want to say this is ministerial, we have the burden of proof, and they don't have the burden of doing anything other than what they did here, which is submitting an unsigned and an unidentified insurer. The other final point that I'll make is that he adopts a standard that I think the court can pick up on, which is if something can be identified through the reasonable exercise of due diligence, that that's an appropriate showing. I submit to you that they did not do that here. They didn't come forward with evidence that they had done that here. And if the court allows these claims to be just submitted and then we are forced to assign them, then we are circumventing and ignoring 3173A, which we request that the court not do.
I just have one question.
Yes, sir.
I'm curious. If you know the automobile's registered owner, where is the information to ascertain whether at a particular point it was insured?
It's my understanding that there is a database on that, Your Honor. I can't stand here and give Your Honor the specifics of it because okay. I've never had to look, so I apologize.
Thank you.
Thank
Case
you.
is submitted.